Hey everyone, welcome back to the channel. In today's video, I've got a few updates related to sovereign citizen cases involving made-up corporate entities that I've discussed before. We'll kick things off in Michigan with new developments in one of the most talked about figures I've covered so far, Jal, of the Lockhart family. While Jal himself doesn't make an appearance this time, another individual with the Lockhart name does. Judge Perkins from Michigan's 36th District Court makes it clear that he has a long memory. When we last checked in, Judge Perkins had ordered the individual to serve a 30-day jail sentence for contempt of court, a requirement that had to be completed before the case could proceed any further. With that context, let's get started.
We'll call the city of Detroit versus, is that Amir Lockhart?
Lamar Lockhart.
It's Lamar Lockhart. I'm
Oh, okay.
Lockhart. I'm looking for an Amir Lockhart. Lockhart, didn't I ask you this before? Were you in front of me before?
Yeah. Yes, I got
the sovereign citizen Lockhart, are you?
me sovereign citizen.
Have you ever espoused any of those sovereign citizen views? I ask you a question.
Said no. Can you hear me?
Hey, flip your camera over. You're not in the toilet, are you?
Oh, I'm in the locker room.
Oh, very well. All right. You're not you're not the Lockhart that has the sovereign citizen views that we had a couple of years back. I'm taking that as a yes.
No. Can you hear me?
I can hear you.
Yes. No. No, couple years back. No.
Have you ever come in front of me with the sovereign citizen argument?
No.
Have you ever come in front of any judge with a sovereign citizen argument? All right. This is City of Detroit. I have Jamil Amir Lockhart. Case number SP 1247989, counts 1 and counts 2, and count 3. SP 1706461. Appearance for the record, please.
Good.
Oh, he's not on the docket. He's I guess walking in now. What?
No.
The last name is hyphenated, if that helps.
Lockhart
hyphen
Simon.
Simon.
Okay, that would change things.
Okay. I was a little worried for a second.
And Judge, I remember the face of the gentleman you're talking about. This is not the gentleman.
And this is not Jamil Amir Lockhart. That's the one we're looking for, right?
Yeah, the one you're asking about. Yeah, this is not that gentleman.
A judge having that kind of memory is never a good thing, especially when, 2.5 years later, he still remembers your full name the moment your last name is mentioned. Before moving on, a quick word from today's sponsor, Aura. With recent data breaches exposing millions of people's personal information, Aura helps protect you with identity monitoring, credit locks, data removal, and a secure VPN. If privacy matters to you, check out Aura using my link for a 14-day free trial. Thanks to Aura for sponsoring today's video. Now on to the next case. Out of Georgia, Ricky Pierce, who is facing murder charges for killing a man walking his dog and stealing the dog. We last covered this case 7 months ago, when Pierce refused to enter a plea and has been sitting in county.
Good morning, Mr. Pierce.
Good morning.
How are you?
All right.
Good. It's been a minute. I'm going to try it again. Your mom has been calling saying, where's discovery? And my staff explained that I tried before to give it to you, but we got a little sideways on some other things. This is the discovery in your case. Although the bag you brought in looks like it's got a whole lot of stuff. That's not discovery in there?
No.
That's your legal research, et cetera?
Yeah, a lot of issues and stuff I need to discuss with you.
Okay.
And I have some documents and stuff I need to give you too. But my problem is I was supposed to be getting notarized today. All last week I've been trying to get my documents notarized, and the notary haven't been at the jail. So
Okay.
I was gonna mail it out last week, but I'm still, I had my family called me to jail and asking why haven't they came up and notarized my document that my family brought to the jail for me to sign and notarize.
Yeah.
So I'm having issues with it, but I was supposed to be sending to you, the DA, and the court clerk certified mail, but
Okay.
they haven't notarized any of my stuff.
Well, we'll wait on it. I mean, if you need it notarized, you should get it notarized. I don't know how frequently the notary comes, but that's different from you getting the discovery. So I'm gonna give this to Deputy Gordon. He's gonna add it to your big old bag there, but this is all of the paper discovery. And I say paper because there may well be some video, whatnot, but as you're reading through that, if you identify that there is, video or audio discovery and you want to watch it or listen to it, you just need to let me know. We'll bring you over here so you can watch it or listen to it.
Okay.
All right.
And I want to discuss about the recusal, and by you denying my recusal on ground that my recusal affidavit wasn't notarized, and I had the counselor email you and tell you that he in fact notarized my recusal.
So the one I have isn't notarized. So I ruled on what I got. I did not receive a notarized anything.
Reason being because the counselor Glenn, his notary is not the ink stamp. It was the press the engraved in the paper. So when you send the copy, when you get it copied, because my copy didn't have it on it either, but it was in fact notarized.
Okay.
And I had counsel. I even documented his book when he notarized it and everything. I had him email you to in fact show you that if you put the original document, it was notarized.
Okay, could be. You're welcome to renew your motion if you want to, but the one that I received wasn't notarized. At least I couldn't tell that it was notarized. You've helped me understand that maybe there was some kind of one of those, I think they call it embossed.
Oh, that's what it's called.
Yeah, but that wasn't evident from what you submitted. So if you want to file other things, you're welcome to do that.
Is no way you can put the original document and see that it was notarized?
Where would the original document
I mean,
be?
with the court clerk, I sent it to her. Then I got to understand, she's not going to file no affidavit if it wasn't notarized.
Okay. No, she's going to file whatever you give her. That's their job.
Because I have sent the document before or affidavit and it wasn't notarized. She sent it back saying that it wasn't notarized, and I had to get it notarized and sent it back.
Okay. Well, I'll tell you what. I will see if there's an original. I just usually see electronic things, but if they've got a paper version, I can take a look at it.
Yeah, because he said the counsel said the reason he do that stamp because they can't copyright it or something. He said so he do the engraved one. They engraved the stamp inside the paper.
Yeah.
And it's not the ink. It's not the ink. I'm
guessing they stopped issuing you ink notarizations once they realized you couldn't keep yourself from licking the stamp right off the documents.
All right.
Is it where I can still give you a copy of my document even though they're not notarized?
What is the document?
It's like it's the Declaration of Authority and Assignment that Donald Trump signed off this year. September 30th, saying that I have a right to practice my sovereignty. Because we had an issue by you saying that I don't have individual sovereignty, and the declaration that Trump signed September 30th said that I do. I have document with my legal notice and demand saying that I have the status of a foreign diplomat, which means I have and a foreign sovereign, which means I have foreign sovereign immunity, which is a law that the United States adopted. With all the other countries, which say that only way I'm not immune from the court, federal or state jurisdiction is when they're seeking money damages for personal injury or death, which also proves that I do have individual sovereignty. I have my acknowledgement and acceptance of all charges requesting different information that I'm asking for. I have my common copyright notice that says that the courts are in breach of my common law copyright notice because my name is copyrighted and trademarked, and there's remedies for breach that I have to give to the courts also.
Okay. Why do you think any of those things require an affidavit that's notarized?
Because let me show you.
You don't need to show me anything. You're doing a good job of just describe, because the things you're describing, I've seen some of that stuff before, but it doesn't usually come with an affidavit. But if you think it needs an affidavit and the affidavit needs to be notarized, then now wouldn't be the time to get that to me. You should wait till the notary makes the rounds.
She's supposed to came today, and by me being here, probably going to delay it.
Oof.
Because I have a time for like this one document, this acceptance and another acceptance paper. We have a deadline for y'all to respond to my paperwork. So I still want the paper to give it to you, and I just still send it in the mail.
Okay.
35 mail. Or whatever. I wish the VA is Adam Abate here?
He's right here.
Hold on. This is for you. I got your name on this. You see, it's got the stamps on it.
I see it's got the stamps on it.
Uh,
Why don't you just give it to Deputy Gordon? He'll get it to where it needs to be.
But yeah, I just get copy and send a certified copy.
Okay, will it go into for it to be something that Mr. Abadi or I need to work on, it needs to also go to the clerk and get in the document?
Yeah, I'm gonna send it to the clerk.
Just
I
send it
got
to
the
the
clerk
clerk?
copy in there too. I just didn't put it out.
Okay, make sure they get to the clerk.
Like, because I know you had wrote that, and I also appeared that the order of you establishing jurisdiction, which you put out 3 days later after you denied my motion to recuse. But I feel like this, I know for a fact that that's against the law because you're supposed to cease to act on the merits of the case when I filed my recusal and grant my recusal because it was in fact no right. So you should have never filed the order establishing jurisdiction because I was supposed to be assigned another judge.
If he weren't already behind bars on a murder charge, I'd lock him up for what he's done to the English language alone. And no, your case doesn't come to a halt just because you asked the judge to step aside. That request was denied, and unless a higher court overturns it on appeal, the same judge will remain in charge of your prosecution.
Well, that's why I need to go see if there's an embossed affidavit out there.
And
If there's
also,
not,
and last time we was in court, you said you were going to pause the plea arraignment, and that's another thing. You got me on the trial cam, but I'm really still at my plea arraignment stage because the last time I was in court, April the 1st, you said you were going to pause the plea arraignment because remember you asked me about the issues that I had in court. You asked me why I didn't file the motions on these grounds, and I said I did. Then you looked in the computer, you seen that, you said you didn't see it, and I pulled the stamp copy out that the court clerk stamped and filed in the office. Then you said, you apologized to me and said you're going to get the state the time to respond to my motion, and you were going to make your ruling. The state never responded to my motion. You still made your ruling when the state never responded to it.
I don't have to wait on the state if they don't
But what you
respond.
said in court, Mr. Bedford, Judge Bedford, Your Honor.
So they have a chance to respond, but if they don't, I don't have to wait on them, and I didn't wait on them. But let me look one thing up. You said one thing that makes me a little concerned, and then I want you to spend some time with that discovery because we are moving your case along. You're not going to sit there forever just waiting for trial.
Well, if you still haven't established jurisdiction, this law state that
I'm real good with jurisdiction.
The case did not proceed until you establish jurisdiction. You can't establish jurisdiction if the Foreign Sovereign Immunity Act state that I'm immune from the state and federal jurisdiction. How can you have a jurisdiction on me if it said that I'm immune from the state and federal jurisdiction? Only time I'm not immune from state and federal jurisdiction when they are seeking money damages for personal injury or death.
You'll just have to watch.
And I filed motions on these grounds also. Then to add to that, Your Honor, the United States Constitution Amendment 5 states that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment. Your Honor, he never said that I can be arrested and charged with an affidavit for arrest. It said I can be charged is on a presentment or an indictment. A presentment is a notice to the grand jury of the charges they have investigated. They're supposed to take the information that they investigated, present it to a grand jury. They were supposed to indict me, then put out an affidavit for my arrest warrant. That's violating my Fifth Amendment rights.
Okay.
And anytime the state violates the law to secure a loan, they have to dismiss these charges. And I have the motion that I filed, I have examples of where Donald Trump, they investigated him, they indicted him, then he had to turn himself right here in Fulton County. And the equal protection of law state that what you do to one person, you got to do to all individuals, no matter the personal class. So that's a violation of my rights, Your Honor.
Well, fortunately for you, there are courts where you can challenge that if you feel like we haven't been doing it the right way here. But I'm not finding that you were ever arraigned. We've had lots of conversations.
I done been to 4 different plea arrangements, John. And I was still at my plea arrangement trying to get you, remember you were trying to get me to plead not guilty. And I said, I cannot plead not guilty because that'll be me consenting to the court's jurisdiction.
I've said this before, and it clearly needs repeating. A court's authority doesn't depend on your permission. If jurisdiction required consent, no one would ever agree to be prosecuted, and the entire criminal justice system would grind to a halt.
Maybe that's what happened. You don't have to enter a plea. If you say I'm not entering a plea, then I enter the plea of not guilty for you. But it doesn't.
I disagree with that.
I understand you, and you're entitled to disagree. I feel pretty confident that the law lets me do that. But if I'm wrong, there are smarter judges that you'll get to, and you can try to convince them that that's not how it's supposed to work. But that being said, I'm gonna have to talk with my team about that. Do you want to do arraignment today?
No, I don't, because the case cannot proceed until you establish jurisdiction. You can't try to proceed my case when you still haven't established jurisdiction. You filed an order claiming to establish jurisdiction when you supposed to cease to act upon the merits of my case.
I had already denied the motion to recuse.
On the ground that you never had it.
Well, I'm gonna go look, like you said.
Fact notarized.
You told me that, and so I'm gonna go check. And so if we need to unwind all that, we can unwind all that. We can do this again. You're the one who's got all the time in the world. So you're going to sit tight.
And this declaration of authority and son is evident. The declaration of authority is Donald Trump just signed, and it has a signature on it that he signed. It's in that package that he signed September 30th. Prove that I have diplomatic immunity.
Okay. I look forward to you getting him in here as a witness, explaining how he has anything to do.
I even asked you to subpoena the governor of Brian Kemp to court to testify to these facts. Asked you to subpoena the Secretary of Washington, D.C. all to these facts. And motion that you denied on ground that you didn't have. I've been asking for these things, Your Honor, to prove my issue, my arguments in court, but you still denied me these rights to due process.
You're sitting in a courtroom hearing as we speak. This is your due process. Dragging out fantasies about subpoenaing the Georgia governor, some D.C. official, or even Donald Trump isn't going to magically give you diplomatic immunity. And honestly, this guy's intellectual horsepower is somewhere south of a Taco Bell taco.
Okay. All right, you've got discovery. Please take that with you. I'm going to figure out the arraignment situation, and I'll see if there is this embossed affidavit connected with the motion to recuse that you filed. And if there is, then we'll need to work through your motion to recuse in a different way. If there's not, then the docket is exactly how it should be. I denied it because there was not a notarized affidavit.
You notarized.
Okay, well, you say so, but I got to find it. If it's not with the clerk, then it wasn't notarized.
Okay. Another thing, this public servant question that I needed, is the public servant is on the Secretary of State website. It's a legal document, and it's basically states that anytime a public servant interact with a private American, these documents have to be answered and filled out before you can even ask any questions of me. So this is part of the documentation also.
Okay. It's in this envelope?
Yes.
Okay. Well, then I've got it now. So I'll take a look at it. But step one is I got to go look in the clerk's file to see if there is an embossed affidavit. And if there is, then we'll proceed accordingly. If there's not, then trial's coming up. So make sure you look through that discovery. All right? Have a good holiday.
I'm still getting the appeal that I filed on those the recuser and the established jurisdiction. I'm still waiting to hear from them, right? And I also state that if I have an appeal pending, my case is still stuck in one spot. You're still trying to proceed with my case when I have appealed two orders that you established, and I put my notice of appeal. Both of them is pending. So how am I you're still trying to proceed with my case?
What are you doing with the appeal? Have you filed anything?
I went for the Supreme Court to ask for my briefing.
Have they told you
I
that it's
have
been
a copy of it
documented?
right here also where.
I don't want any more papers. It'll be in the docket, and so I'll take a look. But you're right, if your case is with the Supreme Court, then I guess you'll sit tight until they rule on it. And then if they grant you relief, we'll figure out what to do. If they deny you relief, then you will have been our guest for that many more months.
Another thing I would like to add to the record too, it was a fire at Forsyth County Jail September the 12th. I'm pretty sure y'all heard about it.
Heard a little bit.
Yes, I was, I probably had my mom call and tell you about it. I was the orderly on the floor. So the sergeant that was on the floor, he froze up. I then snatched the fire extinguisher out of his hand, ran in the dome full of fire. The ceiling was on fire and everything and got right up on this fire with a fire extinguisher that was empty. I went in this dome 3 different times and all 3 fire extinguishers were empty. The fire sprinklers never worked it. And then I collapsed and fell out and got rushed to the hospital for smoke ventilation.
How are you doing now? A little better?
Yeah, it's like now that I breathe, like my lungs, like they burning a little bit.
Yeah.
When I breathe, and I have shortage of breath since then.
Well, I appreciate you trying to do the right thing. It's too bad those fire extinguishers were empty. That's not helpful. 3 of them.
It's a lawsuit.
Okay.
And I'm in the process of filing a lawsuit now on those issues.
Okay.
Because I feel like how y'all get paid for this every day to be trained for this, and you freeze up. The officer in the booth, the officer in the tower, she left them locked in the dorm, and I took it upon myself, like, come on, they locked in the dorm, I had to do something. So I basically put my life on the line to try to save 120, 30 other inmates.
It's a shame you couldn't apply that logic back when you took the life of an innocent man who was simply walking his dog. You're absolute garbage, and unless Donald Trump or some future president drops out of the sky to pardon a murder, you're going to spend the rest of your life in a prison uniform, exactly where you belong. With that fool firmly removed from Team Skeptic's scoreboard, saving 123 inmates versus taking 1 life. We're moving on to Texas. There, we revisit another familiar idiot, Vincent Haynes. The last time we checked in was a few weeks before his jury trial, which wasn't live-streamed. What was streamed, however, was his request for a new trial, after the jury found him guilty the first.
Case numbers G 505-4601 and 02, style of the state of Texas versus Vincent Lewis Haynes. At jury trial on November 13th, the jury found the defendant guilty of both charges and assessed punishment. The defendant filed a motion for a new trial and requested a hearing. And the state has filed a response to the defendant's motion for a new trial. And Mr. Haynes, you received a copy of that response, correct?
Correct.
Okay. All right. So, Mr. Haynes, this is your motion. I'll let you go ahead and summarize your argument for the court.
Can I find out if is this a court of record?
Yes, sir. We're a court of record. As I said at the start of every one of these hearings, that everything is on the record, everything is being reported and streamed live as required by statute. And when you had your jury trial, you were given the little pamphlet of information about how to appeal, and that's an appeal from a municipal court of record.
Okay. Okay. I am a natural born living man, and I grant the court's permission to use my name for future return of my equity. I am not a corporate entity. Do you want me to present something in particular, Your Honor?
Sir, you have filed a motion for a new trial, and I'm giving an opportunity to summarize your argument. Then the state may make their response, and then I'm going to rule. So summarize your argument for the court as to why you should receive a new trial.
Okay. I can only point to several facts. Number one, there was no one in the trial that was identified as an injured party. There's no way for me to make amends for whatever offenses the offended party would have against me. And any claims that the prosecutor may have or willed against me, I would like to know if he was doing so under the penalty of perjury. I also, basically, I am trying to make sure that the court knows that I appeared in trial only under special appearance so that I can get the facts and get any presumptions about my name and the use of my name.
You're not an attorney, so there was no special appearance. You showed up because you were summoned on a criminal complaint, and a jury convicted you on those charges.
Sir, I'm going to pause right there. You were not granted any sort of special appearance. You appeared as the defendant charged in a case.
No, ma'am, I did not.
Sir, do not interrupt me. The complaint was read to you. You entered a plea, and you were not given any sort of special appearance. And this is not information that is included in the motion for new trial that you filed. So this is not an argument that you included there as I have read it. So you need to be summarizing your argument that you in your motion for new trial that you have filed. This is your time to make your argument regarding that motion. This is not a time to raise new issues that were not.
Well, it's not a new issue. When I told you I am a natural living person, and that even in your chambers, I did not identify with the all caps, in which you said that's only for reading purposes, and I vehemently objected and I opposed that because I don't want the presumption to go forth. So that is a part of the motion. That is a part of why the request of a new trial is.
All right, continue with your summation.
Okay. So in order for any presumption or any assumption of me being a corporate entity where the court may see, and maybe the court may not see, that I am not a corporate entity and that I can settle and close this matter because the court should be able to identify the court's fiduciary responsibility and allow for this claim to be verified and settled on the record.
All right, is that the summary of your argument?
I mean, couple that with, like I said, there was no person in the courtroom that identified me as offending them or violating any laws.
All right, response, Mr. Bishop?
Yes, Your Honor. The defendant's motion essentially states, and I hope I'm summarizing this correctly, that he feels like his constitutional rights were violated because he did not receive due process. And I pointed the court in my motion or my response the fact that he did receive due process. He had a jury trial. He had the right to face the officer, and incidentally, the officer is the one who would be testifying under penalties of perjury. The prosecutor did not testify. I'm not a witness. The officer would testify under penalties of perjury, and he did testify. Defendant had a right to cross-examine him. It was a jury trial in front of a 6-person jury, which is the number of jurors in a misdemeanor case, and these were Class C misdemeanors. And so the defendant would not be entitled to a 12-person jury unless he was in district court, which is not the case. These are not felonies. They would not be, these are Class C misdemeanors. And so the state would point to the fact that he had a jury trial. He had a right to cross-examine the officer. The officer testified under penalties of perjury. And the jury found the defendant guilty on both offenses. And there's been no other error identified by the defendant that would warrant this court granting him a new trial.
I object.
What exactly are you objecting to? This hearing isn't a redo of your trial, and objections are meant for evidentiary issues, not arguments. The prosecutor is simply making a legal argument, based on the existing trial record, and you can't object to the state summarizing the facts that resulted in your conviction.
Sir, hang on, Mr. Haynes. Go ahead, Mr. Bishop. Have you finished?
That's all that I have, Your Honor.
Mr. Haynes, you have an objection. You may state your objection.
Okay, I object because he's saying that the officer is the one that is testifying. The officer is a peace officer. The officer did not testify as to me hurting him. There was no one in the courtroom that identified me as offending them. The case is not against the officer. The case is the state of Texas, and the state of Texas was not in the room. I didn't see that person in the room. But the constitutional issue is I have a right to face my accuser, and there's no accuser that was identified in the room.
All right.
Therefore, due process is a part of the guarantees under the Constitution.
All right. Thank you very much. All right. The court has read and reviewed the defendant's motion for new trial with attachments and the state's response to the defendant's motion for new trial, and has heard the argument here during this hearing. This is also the same court that presided at both the pretrial hearing and the trial. I'm noting for the record that the defendant, Mr. Vincent Lewis Haynes, was advised several times that these are criminal charges which carry criminal penalties. As the defendant continues to refer to civil matters or civil approaches such as injured parties, fiduciary responsibilities, and making some sort of amends, almost as though it were a restitution. And though this is a criminal case, as the defendant was advised on multiple times during multiple court appearances, the Texas Code of Criminal Procedure, not the Texas Rules of Civil Procedure, control in a criminal court such as this. And under the Texas Code of Criminal Procedure, the defendant did receive a fair jury trial as required by the Texas Code of Criminal Procedure and the Texas rules. The defendant received a 6-person jury trial and was given the opportunity to hear the officer testify. The officer was the accusing witness. The defendant was given the right to confront the accusing witness and to cross-examine the officer. Therefore, the court is denying the defendant's motion for new trial.
Your Honor,
Yes.
Your Honor, even now, you've never really conferred jurisdiction. You've never really established. I question the jurisdiction. I've done all I can to get you, the court, to understand that I'm a natural living person. I'm a live breathing person. I'm not an artificial person.
Mr. Haynes, I understand that every defendant that appears in this court is a natural living person. And this court has jurisdiction granted by the state of Texas and the city of Dalworthing Gardens, and that has been explained to you previously at previous appearances. And once again, we went over that in the court's chambers the morning of your trial. If you still question whether that the court has jurisdiction, you might question it, but the statutes, the state laws, and the city ordinances are very clear, and this court has jurisdiction over criminal charges alleged to have occurred within the city and the territorial limits of Dalworthing Gardens. You are charged with committing 2 Class C misdemeanors within the territorial limits of the city of Dalworthing Gardens. Therefore, this court had criminal jurisdiction over your cases.